I want to point you to a page that's just 3 pages in to the materials for this session. It's actually got the number page 1 on it. This session being the 1045 to 1245. It's a list of statutes that gives you the right, gives your client the right to get information out of the mortgage servicer when you're not in foreclosure. Now, if you're defending a foreclosure case, you have the right to discovery, and you can ask for relevant materials that way. But if there's not a lawsuit yet, the single most powerful source of a right to get information out of the mortgage servicer is RESPA, the Real Estate Settlement Procedures Act, which has a lot to say, and many of you probably know this already, but for those of you who aren't yet familiar with RESPA, RESPA has a lot to say about how mortgages are closed and serviced, including a lot of details about how escrow accounts are to be managed. And for clients who have a legitimate dispute about their escrow accounts or where their payments went, there are substantive requirements in RESPA. But what we're looking at is the simple requirement that the mortgage servicer respond to your client's request for information. You know, it's sad that there has to be a law that requires it, but for any of you who've tried to get information out of your servicers or information to the servicers, you know, they lose it. There is a federal law that requires the mortgage servicer to respond to your client's request for information. And this, you know, when you have a client who really has proof that they've made their payments and they're getting default notices, the way to ask about that would be a RESPA request. You know, here are proof of all the payments made, yet this month's mortgage statement says she's behind and that all these fees are owed, explain why. So that's a good context for using a RESPA request. Another context is HAMP. Let's say that over the phone your homeowner's been told not eligible. Write a request under RESPA. Please explain why you have told my client. And by the way, the qualified written request, it's safest to have it come from the homeowner. I often write up a letter making a request for information, have my client sign it, and then sign it myself as well. You need at least an authorization from your client that the mortgage company can deal with you on the client's behalf. Don't send a RESPA request just with your signature without either also the client's signature or an authorization to the mortgage company that they can deal with you on behalf of the homeowner. So dealing with disputes over HAMP, RESPA, qualified written request, good way to do that. If you want to know who the owner of the loan really is, you know, you're dealing with Ocwen as the servicer, you know that Ocwen isn't the owner of the loan, you want to maybe to start setting up a defense in a foreclosure, find out who the trust, or you want to start looking up the pooling and servicing agreements. You know, here's one reason under HAMP. They've told you the investor has reached its limit under the pooling and servicing agreement, can't do any more modifications. Not that they would ever tell you that in that detail, but if they did, you could pull up the pooling and servicing agreement online if you knew the name of the trustee, or you could just ask them for the pooling and servicing agreement under the RESPA request because they've told you that the investor isn't doing HAMP or won't do HAMP in this situation.
But don't expect that they'll give it to you.
Yep. The thing about RESPA, a qualified written request, if they don't respond within the required amount of time, it sets up a statutory violation that in itself is actionable, that you can sue a mortgage servicer for failure to respond and to respond thoroughly to a qualified written request under RESPA. You have to wait, comes down to about 60 business days. The servicer needs to acknowledge the request within 30 business days and has to get back to you with a written response within 60 business days of the date they received the request. So it's a long process. And to sue them, you have to show a pattern of failure to respond. So maybe you have to send 2 or 3, and at that point you're waiting for a year, which foreclosures probably started, but servicers take RESPA requests very seriously. They will respond to them. What you might end up with is a response that just says, we're right. It might be a 4-page letter that says, you're wrong and we're right. But hang on to those. You may have a RESPA action building that could be useful in, as one of the tools you've got to try to resolve your client's problem with the mortgage. The Truth in Lending Act now has a provision, actually it's always, it for a very long time has had a provision that the servicer needs to identify the owner of the loan upon written request. That's been there for quite some time. And the Truth in Lending Act provision here is 15 U.S.C. 1641 F2. The site is provided in your materials. But there's a new requirement that within 30 days of the transfer of a loan, the ownership or servicing rights to a loan, that the new servicer has to identify the new owner of the loan. So let's say the loan has been repackaged into a new securitization trust and there's now a new trustee. The servicer has an obligation to inform the homeowner of the name of the new owner of the loan. That's been happening a lot because of the collapse of the mortgage market. There have been a lot of transfers. I'm not sure if we're in for as many as we saw over the last year. And this actually makes it a violation. The new Truth in Lending Act provisions make it a violation to not comply with this duty to provide that information. That's new. The Fair Debt Collection Practices Act also has a requirement that the servicer provide you information about the account if the servicer qualifies as a debt collector, and that's there are some ifs, ands, or buts there. But many servicers at this point in time do qualify as debt collectors because they obtained the rights to service the loan after it went into default. Generally, mortgage servicers are exempt, but now that so many of them have acquired the right to service the loan after default, they do fit under the FDCPA's definition of debt collector. And the last statute is Act 6. There's not an explicit requirement that the mortgage servicer respond to a written request for information, but there is a provision that the fees that can be, the costs and fees that can be collected have to be specified in writing. And to me, that creates a duty that if you've asked them to break down the fees and costs that they're trying to collect, if you ask them to provide you with a written breakdown, that they have to respond. They have to provide that in writing to you. So you can raise the failure to, you can make the request under Act 6 and then have a cause of action under Act 6 if they don't respond. So real brief on how to get information when you don't have a lawsuit and can't do discovery. I think at this point we can move into discussion of bankruptcy.
Yeah, well, this is a very basic introduction to when to think about bankruptcy for your clients. We've all, I mean, it's sort of, when I first became aware of bankruptcy as a legal services lawyer, it was our preferred method of dealing with foreclosures. It was a great solution because for lenders who refused to work out payment problems with clients, it basically forced them to accept payment plans over anywhere from 3 to 5 years. And with the rise in predatory lending and the rise in the defenses that could be pleaded in the foreclosure action itself, bankruptcy sort of fell out of favor, at least in our office, and we started doing it less and less. And then when a few years ago they came in with bankruptcy, quote-unquote, reform, to make it harder for people to file bankruptcy and to increase the amount of paperwork that we had to deal with, we became even less interested in bringing in filing bankruptcies for our clients because it became harder, more complicated, and sort of more of a pain and not worth it when other solutions were available. But I think it's important that we all recognize that there still is a place for bankruptcy in our arsenal of weapons on behalf of our clients to stop them from losing their homes. And we need to just be aware of that so that in appropriate instances, we're still prepared to file bankruptcy for our clients. Does everybody who does this work have in their office bankruptcy preparation software? I can't imagine doing bankruptcies anymore without this. You don't?
I thought of that.
Okay.
How many of you do bankruptcies?
Yeah.
And for those of you who have your hands up, you don't have software that makes it easier to prepare all these documents?
You do, yeah. We use Best Case. I think there was a bunch of other ones out there that are pretty much the same thing. But it, given all of the mathematical calculations that you need to do for means tests and whatever these days, I just can't, and all of the multiple times you have to enter the same information in the schedules, I'd hate to have to even think about bankruptcy without it. But again, bankruptcy still can do what it always could do, which is to force a servicer or lender to accept basically a payment plan from anywhere from 3 to 5 years, to allow your client to get caught up on a mortgage. Essentially, if you don't really have any real defenses and your client fell behind for reasons that have now been solved, and your client, she now has the money available to make payments that she didn't have over a period of time. So sort of the same old reason why bankruptcy was always valuable, it still can come in handy. I guess I'd look to bankruptcy after looking at HAMP and other modification programs, because it would be a shame to go into bankruptcy with a repayment plan when you might be able to make the mortgage better through one of the modification plans. But especially if those plans aren't available, then bankruptcy is still there as a possibility. Other times when bankruptcy can be particularly useful, if you're dealing with a second mortgage situation, you may be able to, if the second mortgage is entirely unsecured, meaning if your house is not worth as much as the first mortgage, but there's a second mortgage as well, you may be able to strip down the second mortgage in bankruptcy and get rid of it. If your loan has a high interest rate and it is due to mature during the period, it either has already matured or it will mature during the course of your bankruptcy plan of 3 to 5 years, then you may be able to repay the remaining balance on that mortgage at a lower interest rate than what's provided for in the mortgage. So those are...
May I add
Yeah.
one more? And I know this never really happens, but just in case, in the off chance that a client comes in a couple days before the sheriff's sale, that's when bankruptcy can help.
Right. It's not, with some unfortunate exceptions, but, which we'll get to, but apart from those exceptions, it will stop the sheriff's sale cold. And it might be the only thing that you can do that'll be guaranteed to stop the sale. Bankruptcy still can be a decent forum to dispute charges and fees and things that have been added on to an account. We spoke at some length about ways to get information through these non-discovery processes, but in the course of a bankruptcy requires the lender, the servicer, the bank to put in their claim for how much is due, and if that claim is, as it usually is, padded with all sorts of illegitimate fees and charges and things that have been applied to the account, in the course of objecting to the claim, you have a very good mechanism to either force them to prove that this is really owed, or, as in what typically happens in our cases, get them to fairly readily knock that claim down to amounts that really are correct or that are provable. If you have truth in lending damage claims or other damage claims for which the statute of limitations has run, then you can typically, in bankruptcy, bring an adversary proceeding objecting to the lender's claim and raise those claims in recoupment without regard to the fact that the statute of limitations has otherwise run. So it may be a way to resuscitate some causes of action, some rights to reduce the, I mean, this would be a recoupment against the claim, so you're not going to end up with, pocketing money as a damage award, but you can reduce the amount that your client owes by an amount equivalent to the damages that you're claiming. So you can resuscitate some claims that you might otherwise have lost. So those are all reasons to still think of bankruptcy as a possible solution for your client. Now, what are some of the downsides or the barriers that exist why bankruptcy might not be appropriate? If your client has filed for bankruptcy before, then you need to look carefully at when and what happened so that you can determine what effect that will have on your on a new bankruptcy case. If I get these details wrong, somebody correct me. If your client has had a bankruptcy ongoing in the past 12 months and the case has been dismissed, then the automatic stay that you get, stopping the sheriff's sale or stopping any other foreclosure activity, is only going to be good for 30 days. And you will simultaneously, with your bankruptcy filing, have to file a motion to extend the stay beyond the 30 days. And in doing so, you're going to have to overcome a presumption in many cases that the law provides, the bankruptcy code provides, of bad faith by essentially showing how circumstances are different now, and this bankruptcy would be likely to succeed, whereas the bankruptcy that you had before didn't succeed. That's a very short, cursory version of this, but I think it's probably adequate for our introductory purposes. If you've had 2 or more bankruptcies live and dismissed in the past 12 months, then there is no automatic stay imposed, and you're going to have to file a motion to impose a stay and essentially show the same things, and it might be somewhat harder to show it. In the rare instance where your client has had many bankruptcies before and there's been an order entered by a bankruptcy court dismissing a prior case with a bar on refiling, then you're going to need to file a motion to allow the bankruptcy case to be filed before you can even actually file the case. That's not very common, but you do see it sometimes, and we do see clients come in to our office who've had any number of prior bankruptcy cases and none of them have worked. I think you do want to look to whether this case really is going to solve your client's problem. I think it can, you don't, I mean, at least we don't want to be spending a lot of effort filing bankruptcies for clients who really aren't going to, don't really have any chance that they're going to be able to succeed at it. We've got enough cases that clients that we turn away because we can't represent everybody, that we don't really see it doesn't really make sense to be filing cases where it's pretty clear from the beginning that it doesn't work. And it may make sense also to be, counseling your client. I think the word that was used in one of yesterday's sessions, a graceful exit or something like that from the home, and try to find another solution, rather than sort of spin your wheels, make your client pay filing fees for new bankruptcies when it's not going to work. The filing fee is somewhere in the vicinity of $300. I was going to look it up before I, 278? 274? 299?
For sevens.
I'm speaking of Chapter 13 bankruptcies, by the way, in terms of representing homeowners. I guess that maybe do I need to discuss the differences? Okay, well. Clients now have to have had credit counseling, bankruptcy counseling, before they can file their petition. They're going to have to either file a certification that they've received the counseling, or in some instances you can file with your own certification that you've had the counseling at the last minute, and then supply the certification later. But you have to have had this counseling before you can file your bankruptcy petition. Your client has to have had this counseling. If not, the bankruptcy, I think it's not dismissed. What's the status? It's as if it's not been. Well, I guess it is dismissed, but it can't be resurrected. You can't do this counseling late, except in the extremely rare circumstances where in some extreme ways it's not available. I think I saw a case a while back from Haitian Creole-speaking clients who, for whom there was absolutely no counseling available anywhere in a language that, in the Haitian Creole language, and there would have been pointless to have tried to have a counseling that they couldn't understand. But there may be some very, very, very limited exceptions, but the basic rule is you gotta have that counseling. Yeah.
I had a judge that was pretty flexible about it, because the client filed pro se, and then had the counseling by the time we had the argument.
Well, that's terrific. That's rare.
Yeah.
That's good.
It's the first time I ever encountered it, and the judge was like, oh, okay, yeah, whatever.
Okay. That, if somebody pressed that might not stand, so get it done, and you can usually, you can usually do it by phone. Your client could probably do it from your office by phone if you need to, but you gotta get it done, and I think the fee is normally $50, but it can be waived, and for any of our clients who are income eligible for us, we ought to have it waived. We have a relationship with the Consumer Credit Counseling Service of Delaware Valley, where they will readily waive the fee for any client that we are involved in. So there's no hassle with them in getting the fee waived. I know that some of the providers of the counseling services are maybe a little more difficult to deal with. Other prerequisites. Clients now need to have filed tax returns. Now, somewhere in my notes here, I had my cheat sheet that said when things have to be filed, and without referring to my notes, I'm hopeless on this. And I don't think I can find my notes right now.
Tax returns are due before the meeting of creditors.
Okay.
It's 2 weeks before the meeting of creditors, that's right?
Everyone hear that? 2 weeks before the meeting of creditors, tax returns have to be filed. You have to have filed all federal, state, and local tax returns that you should have filed. I mean, in the 4 years, I think, prior to the bankruptcy filing. But you don't have to bring all of those to the meeting of creditors. Certain of those have to be filed, have to be brought to the trustee. But you have to have whatever it is that you need to have. You need to show. You also have to be able to say that you filed them over I believe it's the 4 year. It's either the 3 or the 4 years prior. Yeah.
Are you talking just chapter 13 now, or did these apply?
I'm just speaking of chapter 13. I think that's a requirement of chapter 7 as well, but I don't.
7, each trustee is different about what they want you to bring. Many of them only want you to bring 1 year's. It has to be, faxed into the head or emailed in ahead of time. But the underlying stuff you need to look at is 4 years. Let's try to get people to do the returns before we file the bankruptcy, just because we need to know if they owe money on taxes, so we can.
Yeah. Right. What you have to show the trustee isn't necessarily the same as what you have to have filed.
Right.
But you need.
Less.
Yeah, but you have to quiz your clients on whether they have filed these tax returns. And if not, you need to prepare them and file them. And as you say, schedule the debt if there's taxes due that haven't been paid. You have to provide a certain 60 days, I believe, worth of payment advances, pay stubs basically, for clients who have received pay stubs. And the trustee is going to want to see those. If your client has a source of income that does not involve getting payment advances or pay stubs, you're going to need to explain that. There's no requirement in the law that where you don't have the payment advances that you say something about them, but most trustees are requiring that.
Peter? I'm
Yeah.
sorry. When a person has that sort of income also and doesn't have to file taxes, you can get a statement from the IRS that there were no tax returns filed, and the trustee will generally accept it for that year if you can show that that's what their income was.
Okay. We, with our clients who are, say, receive TANF or Social Security benefits, have been able to simply show that that's what the source of income is, and our trustee certainly has not required anything from a client further explaining why it is that they didn't file any tax returns for those years. If it's clear that they didn't, that they didn't have to file tax returns. But for clients who may have a source of income where one ordinarily does file tax returns, then some trustees at least are requiring this. Bank statements for a period of time are also required by trustees. What are some other issues? You got to look fairly carefully at the question of how much equity people have in their homes. If you're proposing to file a Chapter 13 plan, you need to look to see whether all of a client's equity in their home is going to be exempted. There's about the exemption limit for home equity is somewhere in the vicinity of $20,000. I can never keep track of the exact amount. It's indexed, so it regularly is gonna go up, but it's in the vicinity of $20,000. If somebody has more than $20,000 equity in their home, then they're gonna have trouble saving their home through a Chapter 13 plan unless they're also able to pay off through their plan whatever unsecured debts that they have. So you gotta look carefully at that. There are ways to try to find out what home value is for the purposes of assessing a client's equity. Your local taxing authority will have some kind of determination of the value of the home. Whether your trustees will accept that or accept that times a multiplier or something like that will really depend on how your trustees, what your trustees require. There's some websites, one from Bank of America, one from something called Zillow.com, Zillow, that purport to give valuations of, or approximate valuations of properties. We find that these are wildly inaccurate, but where the amount that they give suits our purpose, we might try to use it. Yeah.
I was just gonna say, I looked at Zillow.com and other related matters, and it's all over the map, and for my personal residence, it doesn't even describe it correctly.
Yeah.
It doesn't have enough bedrooms.
Yeah.
So I really wouldn't be relying on that.
But that's the same for my taxing authority, though. So I don't think any of these are really accurate, and right, use it if it helps you.
Right, I mean, it's short of having our client have to pay to have an appraisal, that if you can find one of those online resources that gives you a number that fits, so that amount is gonna be, the equity is fully exempted, I would present that to the trustee, and then if the trustee doesn't want to accept that, then the trustee may require an appraisal, but it's better than having your client pay for the appraisal from the start.
And you may know in advance what it is that your trustee is likely to accept or not accept.
I was
Questions?
just gonna say, our trustee accepts market analysis by a real estate agent.
So get a
Oh,
broker's
wow, great.
opinion, yeah.
That's what I was
Which is
gonna
a bit
say.
less-
Usually a realtor will do that for free.
Right, so that's, and I should have said that, that would be the first choice. An appraisal, a full appraisal is not necessary. I sometimes want those when the value of the house is so much lower than what I think all the other market indicators are that I've used. And if I think there's gonna be a court proceeding in the bankruptcy that requires me to prove it, then I start that out with the appraiser, because I think I'm gonna need that down the line anyway.
You also want to look to what level of unsecured debt your client has. Partly because if you've got an exemption problem, then that unsecured debt is going to have to be paid off through your plan. And partly because if your client does have a tremendous amount of unsecured debt that can be discharged in the bankruptcy, that might be another reason why you might look to bankruptcy as a solution to the mortgage problem and solve the unsecured debt problem at the same time. So that's useful. I think I've reached the limits of my very, very basic talk about when to look to bankruptcy. If anybody has any questions or comments, or else we can move on.
And there's one other bankruptcy-related topic that we wanted to cover in this session, and then I think we're done, except for questions that you might have. There have been some cases out of a couple of bankruptcy courts lately that really blow the cover off of mortgage servicing abuses. Now, they arose in bankruptcy court because in bankruptcy court, you typically are fighting about the last detail of how much your client owes to get caught up, or in one of these cases, to pay off the mortgage. Outside of bankruptcy, I mean, my clients rarely have enough money to just cure the arrears. I mean, I guess if they're getting a HEMAP loan, then that becomes an issue, but HEMAP takes place before a foreclosure. Well, it doesn't always. I mean, you could fight in the context of your clients received HEMAP, and the mortgage company is asking for more money to be paid by HEMAP than you think is proper. You might also have a client who happens to have enough money to get caught up on the legitimate mortgage payments, but there are a bunch of fees that have been added in that they don't have on hand. If your client's been given a HAMP modification and they've gone through the 3-month trial period and the mortgage company has sent you the final modification and the principal balance is much higher than you were expecting, that's another occasion outside of bankruptcy where you might want to fight about how much is really owed. But the bankruptcy context, this comes up repeatedly, and judges in bankruptcy court are used to the fights over how much the homeowner owes to get caught up on the mortgage.
Here's the case for everybody should read, because apart from what Beth's saying, it is absolutely fascinating, and it will give you tremendous insight into why it is that when you try to contact opposing counsel in any kind of foreclosure matter, they can't tell you anything. This is In re Taylor, and it's found at 407 Bankruptcy Reporter 618. It's a decision by Judge Sigmund. It's very, very long, but it is absolutely fascinating. It involved a claim brought by the Udrin law firm, which they were unable to respond to the multiple requests by the judge for information in support of the claim that they were making. And in here, you will learn why it is that they don't have a clue what's going on with this loan.
If you flip 4 pages into the materials, the handout for this session, there are a couple of pages that summarize the Taylor case, plus a couple of cases that preceded Taylor that I think were the real model for this, by Judge Magner in the Eastern District of Louisiana Bankruptcy Court, which did what Judge Sigmund did a couple of years earlier. And both of these, well, actually there were 2 Judge Magner cases and a Judge Sigmund case, looking painstakingly at what the mortgage servicer had added by ways of fees and costs to the mortgage account and picking them apart fee by fee by fee. In Judge Magner's cases, the issue arose because the homeowner wanted to refinance and had worked out a refinancing, and Wells Fargo sent a payoff demand that exceeded the amount that was anticipated and exceeded the amount that was available in the refinancing. And so it threw a wrench in this homeowner's ability to refinance. And then in Judge Sigmund's case, it arose in the context of an objection to the proof of claim filed by the mortgage company. Now, one thing that was interesting to me is that the debtor's lawyer, and the mortgage company settled their claim objection, right? So it's off the table, but Judge Sigmund went ahead and analyzed this because she was outraged with what the mortgage company had done. Now, in the Judge Magner's cases that involved Wells Fargo, and Judge Magner awarded attorney's fees and sanctions in both of those cases, so that the lawyer who brought the case was paid for all the hours it took to litigate it. In Judge Sigmund's case, again, the claim objection had been resolved, so there was no claim for attorney's fees. The cases are long, as Peter said, but they're really worth reading because it explains what's going on between the servicer and sub-servicers and these companies that are hired to handle in huge volume foreclosure and bankruptcy proceedings on behalf of the lawyers and the servicer, and that the lawyers who are filing motions for relief in bankruptcy are filing them with averments of fact that have not been affirmed by anybody. It's all spat out by computer. Nobody's reviewing them, and the lawyers are signing on to them without having taken, as Judge Sigmund points out, even the steps that are needed by the rules of professional responsibility for a lawyer making a representation to a court. Outside of bankruptcy, these cases are useful for us to understand how the mortgage companies are adding fees and costs into the accounts. Judge Magner, in particular, points out the practice of charging multiple late fees when you've really only missed one payment, and the fact that happens because the mortgage servicer, this kind of gets into the issues of how servicers get their money versus how the owner of the loan gets their money. Servicers have three main sources of income. One is a flat percentage rate that they are paid by the owners of the loan to service. A second are the fees, the late fees, inspection fees. Those kind of fees are handled by the servicer to the extent that they can cause more fees to be incurred, they get that money. The third source of income for servicers is the interest that's paid on escrow accounts, or money that they're holding in suspense. You know, when your client has made a payment but it's not applied yet, multiply that times millions of borrowers, and the interest on that money ends up being a significant source of income for the servicer. So when your client makes one payment late, and the mortgage company gets the next payment, and they apply that payment to the late fee first, they take that right off the top, they're actually in violation of what the note says about the order in which payments will be applied. Pretty much every single note says the payment's going to be applied first to interest, then to principal, then to fees. But when the servicer scoops that late fee off the top, there's no longer enough to pay the principal and interest. And so they hold that payment in suspense until the next payment arrives. They scoop the late fee off of the top again, add it into the suspense account, then take the principal and interest, but you're still one payment behind. So your client might only have missed one payment, but there's a late fee being charged every single month. Now, I don't know how many of our clients that's going to apply to. Most of my clients have honestly missed more than one payment. And by the time they've been in bankruptcy and out of bankruptcy, it gets very confusing about what the legitimate fees are, because the mortgage company has added in the foreclosure legal fees and costs and the bankruptcy legal fees and costs with the late fees and inspection fees. One very funny part of Judge Magner's opinion is that she found inspection fees being added during a time when Katrina had the properties underwater, and it's pretty safe to assume that Wells Fargo didn't send its inspectors out in boats to check out the properties. The level of detail that these judges pay to these cases was very gratifying, because these are issues that we often can't afford to litigate, and in the end it's not going to make or break the case if there's 5 late fees that were charged that shouldn't have been. But if you got a case where your homeowner's really close to being able to make the payments, it may be worth digging in the way that these two judges dug into the way that they do their accounting.
Let me just say one other bankruptcy thing I neglected, which is the relationship of bankruptcy to HAMP. There's some general language in HAMP suggesting that that HAMP is available to clients in bankruptcy. And there's at least one specific provision in the August 19th of 2009 supplemental documentation, question 16, if the bankruptcy files for bankruptcy protection during the trial period, is the trial period plan canceled automatically, or is the servicer required to continue to work with the borrower? And basically the answer is it's not canceled, and the servicer has to continue to work with the borrower and work to integrate the HAMP modification into what's required to be paid through the bankruptcy.
I have a question, Beth. I know this really probably does happen rarely, so it's only happened to me this one time, but my client has a huge amount of money now. She's able to pay off the mortgage, and they're coming back with the payoff, which includes all these fees that I'm disputing. But how do I do that outside of bankruptcy?
So is your case in foreclosure now?
Yeah.
So one way that I've thought about, and I filed one of these once and then we settled, so I never had to get in front of a judge. But Act 6 prescribes, now this is, if they really wanted to split hairs, maybe the other side would succeed in saying that Act 6 doesn't apply, because Act 6 states what has to be done to cure a default in the payments. And it prescribes what fees, lawyers' fees, and costs need to be paid. So Act 6 gives the court jurisdiction over this issue of how much is supposed to be paid. So what I did is I filed a motion to determine cure amount under Act 6 in this foreclosure case, where I felt like my client had the money, and if we just could get rid of these fees, she could make the payments. But the mortgage company was digging in their heels, wouldn't accept what I thought was a reasonable proposal, so I filed the motion in court. And in this case, Eileen is mentioning that the client now has money to pay off the full debt.
Right.
Well, I think once a foreclosure has started, what's required is to pay the full debt. right? So you could, I think Act 6 could be, I would file it under Act
Okay,
6
that's a good
anyway.
idea.
And then let them say, oh, Act 6 doesn't apply because this is a payoff, and Act 6 only applies to curing a default. Well, at this point, they've called the whole mortgage in. It's arguable that, you know, she does need to pay. One way of curing and ending the default is to pay the whole amount. So that the court would have jurisdiction under Act 6 to determine how much is due. And, you know, the
That's a good
court in a
idea.
foreclosure has jurisdiction because part of the fight is what's the amount that's due. But Act 6 gives you both the cause of action to determine a cure, or in this case, a payoff amount, and some limitations on what they can throw in there.
Now, I'm rarely interested in such a quick result, but I feel I can deny the averment in the complaint that says these amounts are due and then lists them. I'll deny them for lack of knowledge or on information and belief that it's not due or whatever, and then do discovery on it and try to find out in that way.
Yeah.
And then produce some form of negotiation over
Yeah.
what the real amount is.
Right, and for those, and you could also send a RESPA request, I suppose, which I think when there's you know, litigation, sending a RESPA request instead of a discovery request is questionable. But for those of you who are at programs that are unrestricted, Act 6 provides for attorney's fees. And if the mortgage company is digging its heels in, demanding an amount that in the end you can show they weren't entitled to under Act 6, then you get paid for your time. And I think that's, you know, one way to hurt them as well as benefit your program.
I had a similar question, but the judgment in my case had already been entered, and we were working for a loan modification, and the client brought in the paperwork, shockingly, way too late for me to really get into it, but the fees and stuff, it was like, what is all this stuff?
Yep.
What's your remedy at that
Yeah.
point? I mean, you're kind of at their whim. with
Well, it
the
depends
loan.
on what kind of loan modification it is. As we mentioned yesterday, if it's a HAMP modification,
This
it's
one
not.
was just through the bank, it was just one of their options.
And did she sign it, and now that's what she has to live with?
No, she hadn't signed it yet, but it was due to them. The case was a mess because the father had died, and the client that I was dealing with was the power of attorney for mom who had Alzheimer's.
Right.
So it wasn't a bad loan to begin with, it was just really bad circumstances. The husband died unexpectedly, mom comes down with Alzheimer's, nobody can make the payments. They hadn't made the payments for like 18 months. And so I felt like we were lucky to even get the loan modification in the first place, but I didn't even, and so in this particular case, I didn't even have time because the documents had to be signed in a FedEx envelope. You know, she just basically came in to use our FedEx
Yeah.
drop-off. But I didn't even know what the mechanism would have been. Had she dropped it off to me in time, I didn't really feel like I had much negotiating
Yeah,
power. to
you don't have
grant any of them.
a lot of leverage in that situation.
Okay.
But if the modification papers themselves, and if the modification papers didn't include a waiver of all claims and causes of action, then even if they're signed and sent, you could still raise, and you know, I'm ready to move on to the next case by the time I've got a loan modification that my client can afford, frankly, and I may try to refer it out to a private lawyer, but if there's not a waiver, and you think there's a really good case that fees have been added that would have been challengeable under Act 6, you can still raise an Act 6, you can still sue them under Act 6.
Again, this
for
is
having-
post judgment though.
Well, but I'm sure they've, you know, judgment, they should have been bound by the amount of the judgment, frankly. And if they included anything in that loan modification that wasn't in the judgment, they really should have gone back to court with a motion to reassess the judgment if they wanted to include a higher amount than the judgment amount in that loan modification. So you've got an argument there that they've already, any amount, I think, except for interest,